Imagine for a second that you and your college roommates, let's say there are four of you, come up with a plan to rob a bank.
Okay.
You buy the masks, you draw up the maps, you get in the van, and you actually do it. You rob the bank.
Right.
Eventually, you get caught. Now, here is the nightmare scenario. The prosecutor charges you for the robbery. That makes sense. But then they charge you again, a second crime, a second prison
It's
sentence.
the exact same event.
For the exact same event, they charge you for the agreement to rob the bank.
And if you're the defendant in that situation, you are screaming, double jeopardy. You're thinking, you can't punish me twice for the same thing. But in the eyes of the law, you absolutely can.
That just feels like a trap, but it gets even stickier. What if the crime requires a group of people to even happen? I mean, you can't have a riot of one person. You can't have a duel by yourself. If the crime itself is defined as a group act, surely you can't be charged for the act and for the agreement to act. That would be circular.
You have just stumbled onto one of the most headache-inducing puzzles in American criminal law.
I can imagine.
It's a conflict between the massive power of conspiracy law and a very old, very specific exception called Wharton's Rule.
And that is our mission for this deep dive. We are going to unpack this whole conflict by looking at a specific case, Iannelli v. United States.
The big one.
It's a Supreme Court case from 1975 involving a gambling ring, a lot of money, and a loophole that almost worked. But to understand why Robert Iannelli ended up in prison, we have to step back. We have to understand why the law hates groups so much.
It really does. I mean, the legal system treats a lone wolf criminal very, very differently from a wogak.
So let's start there. The general principle. If I decide to rob a bank alone, that's bad. If I call you and we decide to rob it together, suddenly that's worse. Why?
It boils down to what we call distinct dangers. The law, specifically the General Conspiracy Statute, 18 U.S.C. Section 371, views the agreement itself as a separate evil from the crime.
A separate evil.
A separate evil. Why? Because a group is, exponentially more dangerous than an individual.
I can guess a few reasons. Two heads are better than one, even for crime, right?
Exactly. The source material highlights this explicitly. First, there's just efficiency. A group can divide labor. One person drives, one person cracks the safe, one watches the door.
So you can pull off crimes that a single person just never could.
Right. It makes the crime more likely to succeed.
Okay, so competence is a danger. What else?
Second, there's the psychological piece. It's much harder to back out of a crime when your friends are sitting there waiting for you in the van. The group creates a kind of peer pressure that solidifies the criminal intent.
That makes a lot of sense. If it's just me, I might chicken out at the door. If you're watching me, I have to go through with it.
And third, and this is the big one, the courts always cite a conspiracy as an engine for other crimes.
An engine.
Once you have a crew together, you don't just stop at the bank robbery. You might bribe a cop to look the other way. You might, kill a witness to stay quiet. The group takes on a life of its own.
So the partnership in crime is itself a weapon.
That is a perfect way to put it. And that's why courts, going all the way back to cases like United States v. Holt, have established that conspiracy is what's called an inchoate offense.
Okay, let's pause on that word. Inchoate. That's fancy lawyer speak. Translate it for us.
It basically just means unfinished or undeveloped. So an inchoate crime is a crime of preparation. The agreement is the crime. Even if you never actually robbed the bank, if you agreed to do it and took one small step toward doing it, you are guilty of conspiracy.
And if you do rob the bank...
You're guilty of both. Two crimes, two punishments.
Okay, so that's the baseline. The government absolutely loves to stack these charges, but every rule has an exception. And today, we are hunting for that get-out-of-jail-free card. Introduce us to Francis Wharton.
Francis Wharton was a legal scholar back in the 1800s, and he noticed a logical glitch in conspiracy law. He said, essentially, wait a minute. Conspiracy punishes the coming together of people, but some crimes require coming together just to exist.
Give us the classic example. I know there's a famous one involving pistols at dawn.
The duel. This is a hypothetical one. Imagine it's 1804. You challenge me to a duel. We meet at dawn. We shoot. The crime of dueling, by definition, requires two people. You cannot duel yourself.
Physically impossible.
Exactly. So Wharton argued the agreement to duel is baked into the act of dueling. You can't have one without the other. Therefore, the prosecutor shouldn't be allowed to charge us with dueling and conspiracy to duel.
That would be double counting.
It would be double counting. The conspiracy, he said, merges into the substantive offense.
That feels really intuitive. If the recipe for the crime calls for two people, you can't charge them for being two people. So what are the other classic Wharton crimes?
They usually involve some kind of consensual, illicit conduct. Adultery is the big one. Bigamy, incest. Crimes where the act itself creates a kind of closed loop between the participants.
A closed loop. I like that phrasing. So Wharton's rule is the shield. It says, if the crime requires us to be together, you can't charge us for agreeing to be together.
Correct. But, and this is a massive but, this rule is incredibly fragile. It's not nearly as strong as people think.
And that brings us to the main event, Iannelli v. United States. This is where the rubber meets the road. We have a gambling ring, we have a federal statute, and we have a defendant who thinks he's found the Wharton's rule loophole.
He really did.
Let's analyze Iannelli v. United States. First, to set the stage, what are the legally dispositive facts?
Okay, so Robert Iannelli and 7 other associates were running a massive illegal gambling business. They were taking bets on sports, numbers, you name it. The federal government came in and charged them with 2 things.
Two things.
Charge 1, violating 18 U.S.C. Section 1955. This is a specific federal law that makes it a crime to conduct a gambling business. And charge 2, conspiracy to violate that law under Section 371.
Okay, pretty standard operating procedure so far. But there is a catch in that gambling law, right?
A huge catch. Section 1955, the gambling statute, explicitly says that for it to be a federal crime, the business must involve 5 or more persons.
5 or more persons, so the law itself says you need a group to commit this crime.
Exactly. So Iannelli's lawyers looked at this and said, aha, this is a Wharton's rule case.
Of course.
The crime requires a plurality of agents. It requires 5 people. Therefore, you cannot charge us with the crime and the conspiracy. The conspiracy is inherent in the requirement of having 5 people.
That sounds like a slam dunk argument based on what you just told me about dueling. If dueling requires 2 and gambling requires 5, surely the logic hold.
That was the argument. Now, the defendants were convicted on both counts at trial. They appealed. The Seventh Circuit had actually agreed with this logic in a different case. But the Third Circuit, where Iannelli's case was, disagreed.
So we had a circuit split.
We did. The Supreme Court had to step in to decide.
So here we are at the Supreme Court. What was the core legal issue they had to answer?
The issue is very precise. Does Wharton's rule apply to 18 U.S.C. Section 1955, thereby prohibiting a separate conspiracy conviction, simply because the substantive statute requires the participation of 5 or more people?
Iannelli says yes. The government says no. Now, we need to understand the test the court used. This is where we get technical. What rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
Sure. The court first clarified that Wharton's rule is not a constitutional command. It's just a judicial presumption, a tool for figuring out what Congress meant. So the rule they applied is a rebuttable presumption test.
Okay, a rebuttable presumption test.
And it has 3 distinct elements, or steps of analysis.
Mm-hmm.
First, does the offense fit the classic Wharton characteristics? Is there a congruence between the agreement and the offense?
Okay, element 1.
Second, does the offense pose the distinct dangers of general conspiracy, or is it contained like a duel?
Element 2.
And third, and this is the most important one, is there discernible legislative intent that overrides the whole presumption?
Okay, that is a heavy framework. Rebuttable presumption basically means the court starts by assuming Wharton's rule might apply, but the government can, well, smash that assumption if they prove these other points.
Exactly. It's a thumb on the scale, not a brick wall.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step to see exactly how Iannelli's argument fell apart. How did the court apply the first element, the classic Wharton characteristics?
Okay, so this is where we look at the nature of the crime itself. The sub-issue here is a big gambling ring fundamentally similar to something like adultery or dueling?
And what defines a classic Wharton crime?
The definition is that the parties to the agreement are the only people involved. In adultery, it's just the 2 lovers. The consequences, legally speaking, typically end with them. It's a private affair.
And how did they view the gambling ring in comparison?
They said it was completely different. The court noted that in a large-scale gambling operation, the 5 people running the business are not the only ones involved. Who else is there?
The gamblers. The people placing the bets.
Correct. The bettors. The court analyzed this and found that gambling activities are designed to elicit the participation of additional persons of third parties. Unlike a duel, which is a closed loop, a gambling ring is an open net trying to catch as many customers as possible.
So the conclusion for that element.
The conclusion was that the classic Wharton characteristics were not met. The consequences of the crime were not restricted to the parties of the agreement.
That's the third-party exception you hinted at earlier. If I buy drugs from you, maybe that merges. But if I buy drugs from you, and you have a supplier and a lookout and a whole customer base, the loop is broken.
Precisely. The involvement of the public just changes the whole calculus.
Understood. Now, what about the second element, the distinct dangers test?
So here, the court asked, does the agreement to run a gambling ring pose the same threat as the gambling itself, or does the conspiracy part add something extra? Remember our distinct dangers from the beginning.
Efficiency, complexity, the crime engine.
Right. Does a gambling ring act like an army?
And did it?
The court said yes, absolutely. They analyzed the nature of organized gambling. It requires significant coordination to handle the odds, pay off winners, collect from losers, hide the money.
It's a business.
It's a criminal business. And the court concluded that a gambling conspiracy poses distinct dangers, quite apart from the individual acts of betting. It's a breeding ground for other crimes, loan sharking, tax evasion, bribery. Unlike a duel, which is a one-off emotional outburst, a gambling ring is a sustained enterprise.
So the conclusion on the second element.
The conclusion was that the nature of the crime weighs against merging the offenses. The conspiracy is a separate, larger threat.
So Iannelli is 0 for 2, but the final element is usually the trump card in these statutory cases. How did the court analyze the third element, legislative intent?
This is, for me, the most fascinating part of the ruling. The sub-issue is, did Congress intend to merge these crimes when it passed the Organized Crime Control Act of 1970?
And Iannelli's argument was, look, Congress wrote 5 or more persons right in the law. That proves they wanted to treat the group aspect as part of the crime, not as a separate conspiracy.
It's a logical argument.
Yeah.
Why else put the number 5 in there?
Right.
And that's exactly what the court had to answer. Why the number 5? Was it a definition of the behavior, or was it something else entirely?
And the answer was?
The court analyzed the legislative history and found that the 5 persons requirement was purely jurisdictional.
Jurisdictional. Break that down for us.
Okay, so gambling is traditionally a state crime. Local police handle it. The federal government, the FBI, isn't supposed to be the local vice squad. They only want to get involved if it's a really massive problem.
I see where this is going.
So Congress didn't use the number 5 to say gambling requires a group. They used the number 5 as a filter. They were basically saying, if it's less than 5 people, it's too small for us. Let the state handle it. If it's 5 or more, then it's a major proportion and the feds will prosecute.
Oh, that is a crucial distinction. The number wasn't about the nature of the crime at all. It was about the size of the target.
Exactly. It was just a size filter to save federal resources. And because of that, the court concluded that Congress had no intent to merge the conspiracy charge away. The silence of Congress on conspiracy, combined with the very clear jurisdictional purpose of the 5-person rule, meant the presumption was rebutted.
And after analyzing all the elements, the nature of the crime, the dangers, and the intent, what was the court's final conclusion?
The Supreme Court affirmed the convictions. They held that Wharton's rule does not apply to 18 U.S.C. Section 1955. Robert Iannelli and his associates could be punished twice. Once for the conspiracy and once for the gambling business itself.
Tough break for Robert, and I'm assuming this wasn't a unanimous love fest on the bench.
No, not at all. Justice Douglas dissented, and he dissented heavily. He went right back to the double jeopardy argument. He said, look, the evidence you used to prove the 5 people is the exact same evidence you used to prove the conspiracy. You're using the same facts to lock a man up twice.
He thought the prosecutor should be forced to choose.
One or the other, but he lost. The majority view is the law of the land.
So the takeaway is, don't assume ancient common law rules are going to save you from modern federal statutes.
That's a very good way to put it.
Okay, we have a lot of law students and curious professionals listening who might face a fact pattern like this, maybe on an exam, maybe in a compliance meeting. We need to systematize this. If I spot a group crime issue, what is my checklist?
Let's synthesize this into a diagnostic checklist. If you see a conspiracy charge alongside a substantive crime, run this mental software. Step 1. Identify the charges. Are there 2 distinct charges? One for general conspiracy, like Section 371, and one for a substantive offense. Step 2. Check for a plurality requirement. You have to read the statute for the substantive offense. Does it explicitly require multiple people? Does it say 5 or more persons? Or an exchange between 2 persons?
And if the statute just says anyone who robs a bank, Wharton's rule is totally irrelevant. You just skip
Cool.
it.
Yeah.
But if it says it takes two to tango, you move to step 3.
Right. Step 3, apply the presumption. You start with the presumption that Wharton's rule applies and the crime should merge. The defense attorney in your head should be yelling, merger.
But don't get too comfortable.
Never. Because step 4 is the rebuttal test, using the Iannelli factors we just discussed.
Okay.
You ask yourself, is this a classic private crime, like adultery? Or is it a complex enterprise with third parties, like gambling? Does it pose distinct dangers, the army versus the street fight? And crucially, look at the legislative intent. Did the legislature use that number just to establish jurisdiction?
And step 5 is the outcome.
The result. If the legislature wanted to target large-scale organized crime, the presumption is blown up. Both convictions stand. If it's just two people engaging in a private illicit act, the merger probably holds.
That is incredibly helpful. It turns a very messy, abstract Supreme Court opinion into a clear flowchart.
That's the goal. Law isn't magic. It's just a very, very rigorous categorization system.
So, to wrap this all up, just because a crime takes a village to commit doesn't mean you can't be charged for the village meeting and for the crime itself.
That is the perfect summary, and I'll leave you with this one final thought. The court in Iannelli made an interesting point at the very end of the opinion.
Ooh.
They said that just because prosecutors can charge both doesn't mean they must. They left this to the sound discretion of prosecutors.
Which is a very polite way of saying we trust you not to abuse this immense power.
Exactly. And it raises a lingering question about the power of the state, doesn't it? When the government has the tools to pile on punishment, to turn one act into 2 crimes, or 3, or 4, is it always justice to use them? Or does that distinct danger rationale sometimes become a cover for just wanting to win at all costs?
That is a question we can't answer today. It's definitely one you should think about next time you read a headline about a big conspiracy charge. Thanks for exploring the depths of Iannelli with us. We'll see you on the next deep dive.